Welcome, grade 12s. We're going to be looking at legislation and going into some of those laws and how to go about ensuring you abide by the Labour Relations Act. So, what are we going to look at? The Constitution of South Africa, the Labour Relations Act, the Employment Equity Act, Broad-Based Black Economic Empowerment, the Skills Development Act, and the Basic Conditions of Employment Act. So, the Constitution is the fundamental law of South Africa. No other law or contract may supersede the Constitution. South Africa has an incredible Constitution. Really, it is one of the best. And the intention of it is to establish a society based on democratic values, social justice, and fundamental human rights. Remember those three things: democratic values, social justice, and human rights. And with that, they brought about the Bill of Rights, which is covered in Chapter 5 of the Constitution. And it basically enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. And there are many different rights. You have a right to citizenship, political rights, a right to housing, food, water. Children under the age of 18 have special rights such as protection from abuse and exploitation. We have a right to basic education. People may not be unfairly discriminated against. We have a right to freedom of trade, occupation, and profession, freedom of association, to assemble peacefully and demonstrate, and we have the right to live in an environment that is not harmful to our health. On paper, our Constitution is incredible. I think the implementation, and that is with so many other things, we kind of don't hit the mark with the implementation of things. The Labour Relations Act 66 of 1995. It came into force because of apartheid. So the aims was to enforce rights relating to labour. There were no rights for a huge population working in South Africa pre-Labour Relations Act. One of the second aims is to promote economic development, labour peace, social justice, democracy in the workplace, providing a framework to solve labour disputes. Employees had rights, which was not there before. Now, you need to know what the implications are. It's a word that you must just know. Implications means positive and negative. You must provide both. So, the positive implications is that it ensures that we have international labour standards. It ensures the basic rights of employees and employers in the workplace are protected. And that includes our right of freedom of association. We can join trade unions, and the employer's right of freedom of association, an employer's organization. So an employer can also have an organization. It provides guidelines on how labor disputes and disciplinary issues in the workplace are to be handled. It's a guideline. Labour Relations Act helps us through this. The negative implications. The trade unions have a lot of power. So it's a political stance. So trade unions like to keep people disgruntled because if you have happy employees, you don't need trade unions. So there is a political stance with the trade unions. And of course, it's costly for a small business that doesn't know Labour Relations Act and gets taken to the CCMA or gets taken to court. So it's very important. What is the importance of discipline, disciplinary procedures, and grievance procedures in the workplace? Now, just like school, you have a code of conduct. You have a discipline policy. In work, it's exactly the same. And the purpose of discipline in work is not to embarrass your employees, but it's to correct behavior. So when you have minor infringements, you've got to be seen as progressive. So you're going to make sure that you are helping, coaching, counseling employees to have the correct behavior. You have to prove that you've had a plan of action and that there's been correction. You can then, once you have tried your utmost best with that employee to get them on the right track, you then go into verbal, written warnings, suspension, demotions, and then dismissal. You have to have a disciplinary policy in the workplace. People need to understand how and what they need to do. Okay, so disciplinary policy is basically guidelines of acceptable behavior. And every company has different disciplinary rules. Okay, and then you've got a grievance procedure, which is the procedure of how to handle when you are aggrieved, when you are angry, when you are upset about something. For example, at school, if your parents are upset with the school, they cannot go directly through to the principal. They first have to go to the teacher. If the teacher doesn't help, they then go to the HOD. If the HOD can't solve the problem and nothing's resolved, you then go to deputy principal. From deputy, you then go to principal. So there is a procedure that you've got to follow in school, exactly the same as in a organization. Now, in order for things to progress, you have to show that there's been substantive fairness and procedural fairness. Now, substantive fairness is ensuring that the procedure was followed. It's very important to follow correct procedures. If you don't follow the correct procedure, you might have to reinstate that employee. You might have to re employ that employee. So, substantive fairness is having a look at where dismissal is due to incapacity, where you are not able to do the job, whether you're too sickly or whether you just don't have the skills to do the job. So, you can be dismissed on incapacity. You can be dismissed on misconduct, where you are not adhering to the rules and you have gone through all those coaching and counseling procedures and now you're going to be dismissed, or operational reasons, which is where the business is now becoming insolvent or no longer needs you. They have restructured and they have to prove that they no longer need you as a resource. So, when you have a look at dismissal due to incapacity, examples include poor standards of work. You're not able to do the job. The employer has to prove that the required work standard was fair, that you're not asking for the impossible, and that you have tried and trained and given the employee as much coaching and counseling as possible. You could also look at a demotion. So when someone hasn't got the ability, you might be able to say to them, I would say the first port of call is, you're not able to do the job. We're going to demote you and we need to move you to a different department. And you have to be proving that this person hasn't met the standards. So the other way in which you could be in capacity is poor health. So the employer should try to modify the job to try and accommodate that employee. You could possibly have extended unpaid leave or a transfer to a position where they are able to still work. When I was at a company, we had a wonderful young man. Well, when I say young, 30s, 40s, who was in the depot, and he had to be very hands-on and very kind of running up and down, and he unfortunately contracted a disease that kind of got him incapacitated, and we then had to transfer him through to a office job where he could just work behind a desk and didn't have to move too much. So that's something that you could possibly do. The second dismissal is based on misconduct. And that is where your disciplinary code stipulates the offenses. So, where you have misconduct is abuse of company property, a threat to safety, alcohol, bribery, fighting, or illegal industrial action. Okay, so those are the ways in which you can dismiss with misconduct, but you have to prove all these things. The third element, operational, is retrenching. So you actually go and retrench staff or you restructure. There could be economic reasons for an operational issue that the business is not making money anymore. So you're closing down that division. Automation, where you are automating certain areas of your business, especially in the warehouse, and you don't no longer need a human. You are using a machine or the business is closing. Okay. So that is all ways in which you can dismiss someone based on substantive fairness. Now, when you are looking at misconduct, I just want to go back to that. You have to prove it. I told you that before. You have to establish that the rule was broken. You have to establish that it was a valid rule, that the rule was not a silly rule, that the employee was aware. You have to prove that the employee was aware of the rule. So you need to make sure that they have signed policies. You have to ensure that the rule was consistently applied and that you had the appropriate sanctions done before that, which was warnings. Okay. You have to make sure that that's all done because procedural fairness is extremely important. Have a look at the slide. So that the establishing the rule was broken, there was a valid rule, is all procedural. To have procedural fairness, the complaint must be in writing and fully investigated with regards to misconduct. The accused should be advised of the full nature and details of the charges, the date, time, venue of the disciplinary hearing needs to be given. The accused should be given reasonable time to prepare. The accused is entitled to an interpreter. The complainant presents the case. So the employer presents the case of misconduct. The accused then presents their defense. The chairperson of the disciplinary hearing decides on the guilt or innocence. The chairperson decides on the verdict. If the accused is not guilty, this is confirmed in writing and given to the accused, and the matter is closed. The person will still work. If the verdict is one of guilty, then the chairperson considers aggravating circumstances and decides on a fair sanction or punishment. Okay, so there's a lot of things that have to happen before you can dismiss someone in South Africa. It is not easy. That's why HR is so important, because you've got to make sure you hire the right person. Dismissal due to operational. What procedural fairness must you prove that you have followed? So we looked at the substantive fairness in terms of the reasons why operationally you could. Now it has to be procedurally fair. So possible steps were taken to prevent this. So were you making sure that the business was running optimally? All reasons need to be considered. Consultation with the workers must be shown that you've had meetings. What is the criteria for retrenchments? You have to prove and show who you retrenched and why, and good reasons. What were the notice periods given? Was there severance pay? Was there pay given to people saying, I'm going to ask you to leave. Here is money that we're going to be giving you if you take this retrenchment, if you take the severance pay. So you're almost paying people off to leave so that you don't have to retrench. And then have you told your employees that if there is a change in business, that re-employment could possibly be given through to the employees that you've retrenched, that you would contact them and say, we are back on track, we're able to hire you. Unfair treatment and unfair dismissal. Okay, so unfair treatment. When you look at unfair treatment, you have to look at the following types of actions. So there could be unfair treatment with regards to the allocation of benefits. So maybe some people are getting certain benefits and you're not. That will be seen as unfair treatment. Unreasonably long probation period. Normally, a probation period is 3 months. If you're saying 6 months probation, a year probation, it's a bit unfair. So you're kind of still giving yourself, the employer's giving themselves leeway to still say, sorry, you're not really the fit for us. So we get you in for a year, you give us all your skills, and then we kind of say, no thanks, you didn't really do the job properly. So that would be seen as unfair. Unfair discrimination based on race, gender, language, religion, culture, sexual orientation, age, disability, political orientation, etc., etc. If you are seen as discriminating against, that is seen as unfair. But remember, grade 12s, the limitation clause comes into effect. Rights are not absolute for the white male. Okay, so when there is, if there's unfair discrimination in the sense that it is a white male trying to apply for a job and it is an affirmative action position, they cannot say it's unfair. The limitation clause comes into effect because that limitation clause is readdressing the imbalances of the past, apartheid. Okay, if a job requires a specific orientation, if it is a church and is looking for a Christian minister, you cannot have an atheist applying for the job. Okay, you can't then say that's unfair discrimination. Do you see? It's not going to work. Okay. You can also then look at unfair suspension, where they've been unfairly subjected to any form of disciplinary action, and they would then take the business on based on unfair treatment. What is unfair dismissal? Unfair dismissal is when the employee is dismissed because they've participated in activities of a trade union or workplace forum. Cannot dismiss them. A protected strike is unfair if you fire them because they were on strike. The employee is dismissed due to pregnancy or any reason related to her pregnancy. You cannot fire someone who's on maternity leave. You cannot do that. The employee ends a contract of employment without appropriate notice to the employee. The employee is dismissed due to arbitrary factors. Please highlight arbitrary factors. Race, age, gender, sexual orientation, or religion. You cannot fire someone who is a woman of 50. Do you know? You're kind of ticking age and gender. You cannot do that. And you cannot dismiss someone who is, let me explain it. The employer makes the working condition impossible for the employee, okay? So the employee then ends the contract. They say, I'm not going to be working here anymore. They have actually been unfairly handled, and you've got to be able to prove that as an employee, and it's called constructive dismissal. You can actually prove it that you were constructively dismissed, that you had to leave because your employer made it impossible for you to work there. However, I have spoken to many a lawyer, and they have said it's very difficult to prove constructive dismissal. It's very, very difficult to show that your employer made it so difficult for you to be there that you then resigned and claimed unfair dismissal, constructive dismissal. So yeah, you just got to be careful with that one. Okay, what are the remedies for unfair dismissal? So you can either be re-employed, fabulous, or you could get compensation, which is a maximum of a 24-month salary, or it's a combination. You're re-employed and you get a bit of compensation. It's not an option if the employee doesn't want to go back to being re-employed. Okay, the relationship has been broken. It's intolerable. They don't want to work for the boss. They don't want to go back. So then they would have to look at compensation. Grade 12s, thank you for your attention. I wish you all the very best.